Are we good to go? Okay. Well, good afternoon, everybody. Thanks for being here. I'm Stewart Ledbetter from NBC5, coming to you from the conference room in South Burlington. Never done one of these Zoom debates, so we'll give it a go. This is the candidate debate or forum between the two people vying to be the next state's attorney in Chittenden County. Sarah George of Williston is with us. She's the incumbent county prosecutor appointed by Governor Scott in 2017. She won election in 2018 and is now seeking a new 4-year term. Ted Kenney, also of Williston, a longtime attorney, for a time worked for the Attorney General. Mr. Kenney previously ran for state's attorney in 2006 and now serves as vice chair of the Williston Select Board. There is no Republican running for county prosecutor this year. We have a lot of good questions that have poured in from members of the four sponsoring organizations over the last couple of days. Those organizations include the Vermont Retail and Grocers Association, the Lake Champlain Regional Chamber of Commerce, the Burlington Business Association, and the South Burlington Business Association. I have narrowed them down in the interest of time. So let's begin. And if you could turn off your video so that the candidates will be visible to the audience. If we can do that, and Austin, you might want to do that as well. Why don't we begin with an opening statement? And Sarah George, let's start with you.
Thank you, Stu. Hello, everybody. My name is Sarah George. I'm the Chittenden County State's Attorney. I have been a prosecutor in Chittenden County since January of 2011. It's nearly 12 years. I have prosecuted the first 4 years as a prosecutor. I prosecuted only domestic violence cases. I then went on to have a general caseload where I prosecuted everything from disorderly conducts up through more domestic violence cases, attempted murder, and homicides. Prosecuted thousands and thousands of cases in the last 11 and a half years and found very clearly that our system does not work for a lot of people who come through it. Victims, witnesses, and people who are charged. I have spent the last 5.5 years as the Chittenden County State's Attorney, continuing with this work, continuing with a full caseload, but also working to change the way that our system does things, working to disrupt the status quo and implement policies that are more than just talk, but actually impact people's lives in a hopefully better way. We have a lot of work to do. Our system is still incredibly flawed, and I look forward to continuing this work for the next 4 years as your state's attorney. Thank you.
Thank you. Now an opening statement from Ted Kenney.
Well, thank you, Stuart, and thank you everybody for watching. I'm running for the Democratic nomination for state's attorney because I want to bring new policies to the criminal justice system. I think those new policies are needed, and I think we need to change what's going on now. Last year, we had a record number of opiate overdose deaths, and it wasn't just a record. We beat it by 33%. Last year, crime in Burlington went up 10%. Grand larcenies went up by a 5-year record. Unlawful mischief went up, I believe, by a 10-year record. Burglaries in 2021 were increasing, but the rate of prosecution actually went down. The same situation is going on in South Burlington. Right now, I think we're 1 or 2 cars away from breaking the record that South Burlington set last year for stolen vehicles. And that record was almost twice the average for the 5 years before that. I want to affect new policies. It is not going to be a cure-all, and I am not running for state's attorney saying that the entire solution lies in that office, but we can do what we can do. I would like to start by having what I'd call restorative justice with consequences, where repeat offenders, felony level retail theft, other crimes where the person has come through the system quite recently would be reviewed by the state's attorney. They should not be all sent to the criminal justice system. I'm not a lock them up and throw away the key person. To be clear, I'm the former president of the Criminal Defense Lawyers Association. I had a public defense contract I believe in the people who are in the system. But I also believe that we need to focus on the people who are the victims of crime. I would also like to see.
Thank you. Thank you.
That's
Mr.
my
Kenney.
time. I didn't hear my bell. I'm
That's your
sorry.
time. I'm sorry. That's my sophisticated timing device here. Let's shift
My
to our
apologies.
first, no problem, our first question. In recent weeks, the Firefighters Association and the UVM Nurses Union have spoken out in frustration at the increase in assaults and antisocial behavior they're seeing on the job, verbal, physical, sexual assaults in the emergency department, an attempted theft of one of Burlington's fire trucks. Similarly, members of the organizations hosting this event have expressed dismay over the current state of affairs. They feel unsafe and unsupported as victims of harassment, theft, and in some cases, as we've heard, assault. What do you see as the root of this? What do you pledge to do to increase a feeling of safety if you are elected to this office? Mr. Kenney.
Well, the root of it is multifaceted. And again, I've never said that the answer lies entirely in the state's attorney's office. We do have a significant interplay between all of these different things, though. The opiate overdoses that are going on are, I believe, tied to the retail theft increases and other things like that. So we need to get the retail theft situation under control. We also need to have better conditions of release. But fundamentally, we just need to make sure that everybody is at the table, that the firefighters, that the nurses, that people who feel like they've been victimized feel like there is recourse. So I think the answer has got to be the policies that I was trying to get through in my opening statement, but also just very clearly, I'm not saying the solutions to these problems are going to be easy. I don't believe that they will be, but I believe that we need to get started.
Sarah George.
Thank you. I first want to just say that I'm a lawyer in a family of nurses. So when I heard the press release or the press conference about the assaults happening in the emergency room, I was incredibly upset to hear that. I was not aware that it was as bad as it was. And when I spoke with the nurses that had that press conference right afterwards, I spent over an hour on the phone with them going through particular cases that they were concerned about, to find that those cases had never been sent to our office by law enforcement. So I think it's really important to first note that we can only do things for cases that get sent to us. We don't control and we can't fix things that aren't sent to us. That being said, prosecution of a lot of the individuals that might be involved in these offenses is not going to solve the problem. What those folks need is services in this community. They need help, and of course they need accountability, but that looks different for each person. When I spoke with the nurses about that, they didn't even realize that those cases hadn't been sent to us. So some of this is disinformation in the community about what my office is and isn't doing. But ultimately, these people in our community, especially in the last 2.5 years, due to COVID, having nothing to do with the policies of my office, but entirely due to the incredible amount of people who are houseless right now, people with food insecurity, people who are struggling to find work, and childcare, and all of the other woes and issues that have come with the pandemic are being scapegoated on my office, and we are not the solution to it. There are some things we can do for some of them, but individuals are going to be released pre-trial for most offenses, and that is not going to protect people if those people's needs aren't being met, whether a criminal charge and strict conditions of release are imposed or not. If they don't have a place to stay and they don't have a place to live, they don't have food to eat, they are going to continue to be an issue in our community. So that is what we should be focusing on.
Mr. Kenney, do you want to rebut?
Well, just the things that can be done, I think, need to be done, and they need to be done more effectively. I spoke with the nurses. I talked to them before and after that press conference. I didn't know what they were going to say in it, but you know, they are being victimized. The remainder of the things I agree with. I mean, I'm a Democrat. I was the chair of the county Democratic Committee. Social programs need to be upped. The game needs to be upped on those things. But we're not living in the Great Depression. We don't have 25% unemployment. The things that are going on need to be improved a lot. And I'm not saying that they don't, but what I am saying is that what is going on in the criminal justice system needs to be addressed within the criminal justice system. If somebody needs to have more strict conditions of release to protect the public, then that's something that should be advocated for.
Shall we move on, Sarah?
I think that it is important to note that I am practicing in this court, and there are 14 of us in my office who are working tirelessly to do really, really hard work. And we are implementing conditions. We are asking for conditions of release when we can, but they are ultimately up to a judge. So we are asking when we think it's appropriate, and the judges are deciding and implementing whatever conditions of release they think are necessary.
All right, let me ask about that, because there are several questions in the queue here that speak to this revolving door that many members of our organizations here see. So the question is, do you consider conditions of release imposed by judges in recent cases involving, recidivists or repeat offenders to have been successful in mitigating flight risk and protecting the public? And if not, understanding that conditions of release must be as minimally restrictive as possible, what changes would you like to make? Sarah George?
Sure. I mean, the answer is not as complicated or easy as yes or no. For some people, absolutely. Conditions of release mean something and they follow them, and it actually gets them on a much better track. And we don't have any issues with that person again. And for some folks, again, their mental health needs or their substance use needs are far more severe and far more influential in their decision-making than a condition of release from a judge. I also think it's important to note that during COVID, people haven't been required to come to court. So most people are joining court like this, if at all. In most cases, their attorney is joining on their behalf. So in terms of a risk of flight aspect, that's really just not happening because people haven't been required to come to court. But in terms of following a curfew or staying away from a particular place, those types of things, that works for some people, and for others it doesn't. But that doesn't mean that the answer to that is that we put them in jail until they face trial, when we aren't doing those right now either due to COVID.
Mr. Kenney?
Well, I disagree. The conditions of release that are available under the statute do allow for stricter conditions. By way of example, the man that assaulted the firefighter recently as he was trying to get to an incapacitated person in City Hall Park. He had been charged in January with a simple assault. He had been charged a couple of days later with violating an abuse prevention order. He had been charged following that on May 28th with 2 burglaries, one on Main Street in Burlington and one on Church Street in Burlington. Almost immediately after that, there was a disorderly conduct. Almost immediately after that was when the situation with the fire truck happened. In each of those cases, the conditions of release that were being requested were not conditions such as a curfew, such as release to a responsible adult, such as any of those kinds of things. And again, there are multifaceted things about this. I have plenty of experience with mental health issues, both in my own immediate family and as an attorney. And I have great sympathy for those people, and I want to try to help them. But it doesn't even help this man to have no conditions of release requested. And the judge isn't going to give you something generally that you don't ask for. And it's not going to help. The public. The last thing that happened is that recently he was accused of trying to steal a moped, and when he was confronted, he pulled a knife. Now, mistakes are going to happen, and errors in judgment are going to happen, and I'm not criticizing or laying blame on the state's attorney's office for that in any way. But the conditions of release that could have been requested were not requested in that case, and that's just one case. There are lots of others.
Ms. George, you want to rebut?
I would just, in practice, actually in court, the judges often set conditions of release that we don't request. So that's the truth of what we're dealing with in court. And also that particular case, when the charges made a responsible adult condition legally allowed, we requested it. And that individual is now being held on a responsible adult condition. So Going case by case, we could do that all day, but the reality is that these cases are very complicated, and the prosecutors who have them have a lot of knowledge about these individuals and their cases and the laws that we are allowed to follow or have to follow, than is often in the press or otherwise out in the community. And they're complicated and is not a simple solution.
Well,
Can I add one thing?
sure.
I don't think it's a good thing that the judges are having to add conditions of release that weren't asked for by the prosecutor. That's the only addition I have.
Well, there is clearly a frustration running through many of these questions about repeat offenders going back out on the street and re-victimizing. And one question puts it pretty simply. What do you say to victims of crimes involving repeat offenders who are just free to rejoin the community and do it again? Mr. Kenney?
I would say that I'm not state's attorney yet. I would say that I'm running to try to give people like that hope that there is public safety and compassion in the system. They're not mutually exclusive. And so my answer would be pretty simple.
Ms. George?
Look, I would say that the victims advocates in my office have the hardest job that I can imagine, having to explain really complicated laws to people and explain to people that we understand they were a victim, that we are very sensitive to that, and that we're going to do what we can to hold the person accountable. But them having committed a crime against them doesn't mean that all of their rights are taken away, that our Constitution allows for some very protective rights of their liberty, and that people are only going to be held in jail pre-trial if they have a violent felony offense charged and the court has agreed that our evidence of guilt is great and they cannot be released into the community. The law allows for or mandates that otherwise the presumption is that people are released, even if they continue to pick up criminal offenses.
Mr. Kenney, there's a question from the chat. When you were a defense attorney, were there cases in which the state's attorney on the other side of the courtroom gave your client conditions or asked for a sentence you felt was too lenient?
Sure. Yeah, there were. And being the zealous advocate that I was, I didn't complain much about it.
Let me ask you about retail theft. No surprise that the sponsors are concerned about this. It's a $68 billion industry in the United States. There was a report that suggested Vermont has seen more than $90 million worth of stolen goods and shoplifting last year. Certainly anecdotal reports show increased anxiety around theft and violence toward loss prevention professionals and shopkeepers. So what do you think the state's attorney's role is in reducing or trying to prevent retail theft? How do you plan to protect business owners when they're victims of crime? And do you support retailers getting restitution for these crimes committed against their businesses? 3 questions. Sarah George, let's start with you.
Sure, thank you. So this is something that since the first day I've been a prosecutor, this has been a topic that has been coming up a lot. The overall issue that we face most of the time is that the folks that are committing these crimes have no ability to ultimately pay restitution. And so we issue restitution orders all the time, and the businesses, because of the way our restitution unit is designed, really, they never get the money back. It may ultimately come out of taxes or something, but it's not an immediate fix, and those people aren't getting the money. The businesses are not getting the money they need back. Other jurisdictions have imposed or created units that will give the businesses their money back without it relying on the person charged. I'm not sure how that would work here, but I think something like that could be really helpful to actually, because the reality is they're not getting it otherwise, of trying to figure out a way to do that, because I think the businesses, of course, absolutely deserve to be made whole, and our restitution unit doesn't allow for that with businesses. In terms of how we handle it, the ones that don't involve violence are obviously not they're not eligible for a hold without bail or, to hold people pre-trial. But when it has escalated to violence, the incident at Black Diamond, for example, we charged that individual with a felony assault, ultimately held her without bail, and then worked with the feds. And the feds ultimately prosecuted her and took her case. We do take those cases very, very seriously. I think something that really is important to note is that nonviolent misdemeanors and nonviolent felonies are not being prioritized by our court right now, given our COVID backlog. So we have hundreds that are pending that nothing's happening on. And I think that's giving the impression in the community that we're not prosecuting them. We are charging them, but they are just sitting because our backlog is so long.
Mr. Kenney?
Well, the restitution thing, most definitely there needs to be a restitution order in place. I agree with the state's attorney that unfortunately a lot of these people don't have the resources to pay that restitution order. And so I do think there needs to be a statutory change and perhaps some sort of program that the state should run. Relative to the other things, again, as a former criminal defense lawyer who had a public defender contract, I'm not looking to destroy people, but there do have to be actual consequences that are worse than the thing that you get out of committing the crime. Otherwise, there's, from a cost benefit analysis, there's no reason not to commit the crime. Right now, the perception among the people who are committing these crimes is that there is no consequence that would be worse than that which you get if you succeed in committing it. There needs to be more consequences, and that is not necessarily throwing people in jail right away, but it is making sure that these people are brought into the criminal justice system more than they are now. That's why the restitution program needs to be reviewed by the state's attorney on serious cases. Relative to the Black Diamond incident, that happened on April 18th. That defendant, and again, I have to emphasize over and over again, I don't wish her any harm. She's a real person. But she, on April 1, was followed out of the Dick's Sporting Goods in Williston with felony amounts of retail theft of retail product. She was stopped by the Williston Police Department. She resisted arrest and she assaulted a police officer. And the requested conditions of release for that, and she had prior felonies and prior pending charges. The requested conditions in that circumstance were show up for court when you're supposed to, let your lawyer know how to get a hold of you, and stay away. I believe it was stay away from the officer who was assaulted. More than that, there were clearly over $1,000 worth of product that she had, which would make it a felony, but she was only charged with a misdemeanor. I'm not going to be felony happy if I succeed in this election. Sometimes prosecutors will overcharge things just to gain an advantage. But where a situation like that has occurred, where somebody actually has committed allegedly the felony, that case needs to be brought, because if it's not, then you're not going to have general deterrence for the other people who are in a similar circumstance.
All right, State's Attorney George, how does that sound to you?
It's just not, some of that is just not the reality of what we're working with right now. Mr. Kenney has not been a lawyer in our court for years, and things are very different, especially with COVID. And I think it's really a disservice to the community to give these solutions that aren't actually realistic with what we're doing and what we are trying to do in court. And to say that we should be doing things differently without an actual solution that will work with the system that we have right now.
Mr. Kenney?
Well, we got to try. And if the solutions that, I will say this a million times, if the solutions that I'm proposing don't work, we'll measure the results. And if the results show that they're not working, we'll either tweak it or we'll come up with a new solution.
What is the state's attorney's role, you think, in trying to prevent retail crime? I didn't hear that from you guys. Mr. Kenney?
Well, this is the same thing with any law enforcement situation. I don't think the state's attorney has, and this is probably an answer that's not going to be real popular. The state's attorney, I don't think, has an absolute direct role in preventing retail theft because it's the same as with a law enforcement officer. Law enforcement officer is going to be able to prevent a crime if the law enforcement officer is actually there. The way that it's done would be more secondary effect of things that are in place to make sure people know that they are going to be held accountable, that there will be a consequence that is worse than if they'd gotten away with the crime. And ultimately that even there will be help for them within the system. But a direct ability to prevent the crime, I wish I could say that there was one, but there isn't.
Ms. George, last word.
Prosecutors don't prevent crime. We respond to it. The crime has already happened by the time that we're involved, and we do our best to respond to it and to hold people accountable with the tools that we have. But we don't have, our role should be advocating for community supports and services for the folks so that they can prevent the crime, so that community organizations can be involved in lifting people up and not systems, so that people are better in our communities and therefore not committing crimes.
Next question. Over the last several months, we have all seen news reports that indicate a spike in gunfire incidents, a spike in theft, robbery and assault cases in cities and towns in Chittenden County. An alleged offender in one case had been previously charged or convicted 3 or more times over previous months or years, then released pending appearance. What is the reason for this, and what can be changed to further protect public safety? I mean, this is a recurring theme you're getting, I know, but the gunfire incidents, Sarah George, are a real concern to a lot of people in this county.
Absolutely, they're a serious concern for me. I think it's important to note that only a couple of them have been sent to my office. Again, these cases have not, most of these gunfire incidents have not been solved. I can't do anything on cases I don't have in my office. And for the ones that have been solved, those people are being held without bail pending trial, which is, again, a long way away given the backlog we have in COVID. So people's rights are being entirely taken away when those cases are being solved. Every single case is different. If law enforcement officer is struggling to find probable cause to send a case to our office, the next step is that we then have to prove that case beyond a reasonable doubt. That is a very high burden. It is the highest burden in our legal system, and it is not easy. So if we are resolving cases in a particular way, every case is going to be different based on the evidence we have, the witness availability or witness, whether or not a witness will actually cooperate with our office, will actually show up for trial. We have had to subpoena people over their objection many times to get people to come in and testify in some of these cases. So yes, we make decisions based on every single case, and sometimes that will absolutely mean that someone is released. But it's also important to note that in Vermont, 98% of people are released back into our community. So we have to make sure that when those individuals are released, they are safe to be in our community. And jail doesn't do that. Jail actually, the evidence shows that jail actually makes people more likely to commit violent offenses in the future. So we have to balance both of those things by making sure that people are taken out of our community when we know and have significant evidence to show that they've committed a gun violence incident or a gun or shooting, but also make sure that we're returning them in a safe way when we can, especially if our evidence doesn't support continuing to hold them.
What about that, Mr. Kenney? How can the state's attorney prosecute a crime that has not been referred to him or her?
No, they can't, but there are other things that can be done. The gunfire incidents, I think, are part of a higher, bigger picture. And, when it comes to criminal justice, I think there are a number of analogies that can be made. One of them would be to the health of, somebody's body, where, everything is connected together. One of the difficulties that we have in Vermont is that the street price of heroin is much higher than it is in New York City. You'd think that is a good thing because it'd be more expensive. The problem is what that means is that people, and not just New York City, the people in major cities who have access to these drugs can buy them for retail and come up to Vermont and sell them out. That means that there is a supply. Drug trafficking laws have to be enforced, but more than that, the other things that make up a lot of these things. Again, I've talked to risk prevention officers at major retailers. I've talked to shop owners individually, a lot of them. and I've talked to law enforcement, and by and large, they're saying that the retail theft issues are driven by people who are struggling with opiate addiction. So there are a couple things that need to happen. One is that the retail theft situation has to be addressed, and it has to be addressed in a focused way. The other is stuff that I think is probably beyond, well, I know it is beyond the state's attorney's control, and then that is to advocate for these programs that would help these people with their opiate addictions, with their mental health issues and things like that. But everything is tied together, and we're not going to be able to address the gun violence without addressing all of the other issues that are going on. Now, if that turns out to be wrong, and it turns out that the gun incidents that are going on are actually not related to drug trafficking, and it's possible, but if that is the case, then that which I'm proposing needs to be done anyway.
Okay, question from the chat. Probably a short response. How do each of you feel about implementing or opening a safe injection site in Chittenden County? Mr. Kenney?
I wish the governor had not vetoed the study that was going on. I'm not opposed to it. The difficulty is, and I say this maybe as a vice chair of a select board in a municipality, is that when you're dealing with a major thing like that, there are so many different factors that have to be taken into account that I would actually want a legislative body to study it and address it. If we have the numbers to make it work, if it would be harm prevention, then I'm in favor of it. But those things have to be balanced with the possible unintended consequences, such as people traveling away after they've injected. And in addition, the cost benefit. There are going to be, this would be new money, and the new money, is that the best resource for best application of it, or should it be applied in another way? I'm not opposed to them, but I think we need to know a lot more.
Sarah George, safe injection sites.
I am wholeheartedly in support of safe injection sites. I am the one that convened a commission when I was first elected, first appointed, and did a study, looked at a lot of studies that are done across the world. These are not new. These are happening in a lot of different places. They're absolutely successful. The cost benefit analysis, from my perception, is one life saved is absolutely worth the cost benefit analysis, but many, many lives are being saved. They have 2 or 3 currently happening in New York City, and hundreds of lives have been saved. I think that to talk about opioid use disorder and our overdose fatality numbers, and how this year we've lost at least 23 Vermonters in Chittenden County to overdose fatalities, to talk about that being important to us and then not be doing everything we can to save those people's lives is not something I'm interested in. I want to do everything I can, including a safe injection site, because right now we have a lot of unsafe injection sites in our community, and they're killing our community members.
Sticking with you, Ms. George, a question from one of the members says, you've been state's attorney throughout the entire George Floyd Black Lives Matter movement. You supported defund the police in Burlington and elsewhere. Crime now rampant in Burlington, and there's no recourse for shoplifting and other petty crimes. Are you happy with the decisions you made and the policies you've articulated over the last couple of years?
I am absolutely happy with all of the decisions that I've made. I would just start with, I did not defund the police. I think there's a confusion about what my role is versus what the city council's role is. I have not defunded the police. I absolutely stand by my decisions to end cash bail and to presumptively decline non-public safety stops, all actions and crimes that disproportionately impact the people of color in our community. Our prison population in Vermont is still second in the nation, most disproportionate to our prison population. And the arrests and prosecutions of Black people in Burlington is far more disproportional to the community members of color that we have. So not only do I support and stand by everything I've done, but we have a lot more work to do, and I plan on doing more.
Mr. Kenney.
Well, the racial disparities in the system are huge and they do need to be addressed. They're real. I will say that there were, when the defund the police movement was just beginning, the state's attorney did tweet in favor of that, saying, comparing it to the people who advocate for defunding education, et cetera, and stuff. I don't have the direct wording in front of me. But it is true that the state's attorney's office does not control police budgets. As a Williston Select Board member, I can tell you that we not only did not defund the police, but we had to implement a bonus regimen where law enforcement would get additional money if they stayed in the profession, because the profession is so terrible right now. The racial disparity issues, though, are huge. And they're going to need constant and repeated training and focus on it. I am not in any way thinking that law enforcement is without implicit bias. And I want to say something about that as my last thing on this issue, at least for this question. I think we all have implicit bias. I think I do. I will confess. I think all of us do. The difference is that if you have authority and power, that your chances of you acting on bias that, again, is implicit, that you may or may not even be aware of, go up. And so that definitely needs to be addressed. And it needs to be not just addressed once. It's like, it's like trying to get in shape. You can't just do, 10 push-ups and decide, okay, that's it, I'm in shape now. The amount of training and focus and making sure that these numbers are coming down is going to have to be something that happens for repeated years.
Follow-up question for you, Ms. George. Did you consult with law enforcement agencies prior to enacting your written policy against prosecuting crimes stemming from non-public safety traffic stops? If not, why not? And perhaps you should just explain that policy, what that policy involves.
Sure. So the policy is that our office will presumptively decline or have a heightened scrutiny of charges that stem from non-public safety stops, or otherwise known as pretext stops. And that came from not just the overwhelming evidence that traffic stops were being disproportionately incurred upon people of color in Vermont. There were several studies and articles that came out about that. But then even more importantly, that the drug charges that were coming from those stops were, I believe, 14 times more likely to be on people of color than white people, despite no difference in the amount of drugs use or possessions. Mm-hmm. So that's what it isn't a blanket decline every case. We still look at the cases and decide whether or not that burden is sort of overcome, and we will still charge them if it is a DUI, for example, or some other offenses. I spoke with a lot of law enforcement officers. I've also, I've been a prosecutor for 12 years, nearly 12 years. I have a lot of relationships with a lot of law enforcement officers. I talked to a lot of them about it before and while I was working on it. But if they, I didn't have like a committee on this. I didn't, this was my office working on it and looking at the research and data and writing the policy through that. I didn't have a committee that had a bunch of different people. I used mostly research and data that had been established through Vermont by people doing the research.
Okay, so just if police pull over a person of color for a broken taillight and see a bag of narcotics in the back seat, you prosecute the narcotics or you don't?
It depends on the case. If that's it, they would probably do a search warrant. We would still get the search warrant. The drugs would be confiscated. And depending on what that outcome was, in some cases, no, we probably wouldn't charge it. If it was enough drugs, the feds could still charge it if they wanted, or the attorney general's office could. But if it was a misdemeanor of level or a threshold felony level, we probably would decline to charge that. But the drugs would get confiscated.
Mr. Kenney, how's that sound to you?
It hasn't been just that. The number of DUI cases that have been declined to be prosecuted based on non-public safety motor vehicle stops is significant. But you know, the point here is actually what the goal of the policy is, and I do not agree with the policy. The goal of the policy is to disincentivize the law enforcement from pulling people over in the first place. The reason I don't think that's a reason that's a policy I would not engage in is for a couple of reasons. First of all, I want the traffic laws to be enforced. I like it when people use their blinkers. I like it when they don't coast through yield situations. I think these things are on the books for a reason, and if they're not enforced, then they're not going to be followed. And again, you know, the traffic accidents happen, and you know, this would be one way to make sure that they are cut back on. The other thing though is that you know, 40%, the state police did a study on the number of DUI cases that they get from these kinds of stops. And the number was something along the lines of 40% of their DUI arrests happen when they approach the car or vehicle and they don't know that the person, there's no indicia of intoxication. They don't know the person is under the influence. In other words, they pulled them over for a non-public safety motor vehicle stop. I keep coming back to that. You know, we don't really talk much about DUI with everything else going on, but as a defense attorney and as a plaintiff's personal injury lawyer, I've been involved in DUI fatality cases. And I have a family, and my family drives late at night. I got out of a select board meeting last night at a very late hour, and you know, I want the roads to be as safe as they possibly can. The goal of this policy is to make sure that the police don't pull people over in the first place.
Right.
If that's not the goal, then I guess I'm not sure what the goal is.
Sarah George, you want to rebut?
I do. One, I think that, you know, for people that look like Mr. Kenney, maybe even people that look like me, that's probably all true. But the reality is that people of color are being pulled over at significantly more rates than white people. And that interaction with police officers is becoming increasingly more dangerous and traumatic for people. I hear from people of color a lot who say that they got pulled over for no reason, or for not using a blinker. And the data is very clear that that is happening at a massively disproportionate rate to people of color in Vermont. We cannot ignore that. And yes, that is the goal of the policy, is that police, because they have this bias, whether it's implicit or not, the bias is there, the data supports it, and we need to find ways to limit the number of people of color being pulled over. So, you know, I think it's very easy for some people to say it's not a big deal to get pulled over for a traffic violation, but for some people it is. I also just want to say that, you know, I care very much about traffic offenses. I personally prosecuted Stephen Burgoyne, a 5-count homicide case for killing 5 teenagers. I know very well, the way that some of those crimes can impact entire communities, entire state and beyond. That is not what we're talking about here. We are talking about minor traffic violations that are disproportionately impacting and traumatizing people of color in our state.
Mr. Kenney, final word.
Well, if Mr. Burgoyne could have been pulled over for a non-public safety motor vehicle stop before he went the wrong way on the interstate, I would have preferred that. This is a real issue. It's just, what I'm saying is it's like the policy, I think, is so severe that it's like going to a doctor and saying, the doctor saying I need to lose 10 pounds. And you say, okay, well, I'll cut part of my body off. Well, let's try something else first. Let's, you know, back when the Chittenden Unit for Special Investigations was created, each town had to pony up money to fund that. Municipalities could be asked to do similar things for proper training. And again, this is not, you know, all this is doing is pushing the problem up, so that if there is a public safety motor vehicle stop, then that encounter is still going to happen. I have stood next to people in court who have been racially profiled. I have stood next to people in court who have been treated, in my view, unfairly. I'm extremely sensitive to it, and it's a real issue. I'm not saying it's not. What I'm saying is this solution is pretty severe right out of the gate.
Question for you, Ms. George, from the queue here. Former Attorney General T.J. Donovan, at the behest of the governor, opted to prosecute a couple of violent offenders who you chose not to. Some of those folks are now behind bars, were successfully held to account. Did you make a mistake?
First of all, I think language is really important here. We did not refuse to prosecute those individuals. We absolutely filed charges against those people. We prosecuted those people. I was personally assigned to 2 of those cases, 2 of the attempted murder and 1 of the murders. Only 1 of them is now in jail, and that is because, I don't want to speak for her, but that is because the feds came in and prosecuted her with a case that did not allow for an insanity defense in the same way. And like the government does, we came down with a hammer in hopes of getting a plea agreement, and did get it. She waived like her insanity defense because she was going to go to jail for 10 years on the felony case in federal court. But I think it's important to note that the other 2 are still in the hospital. They are not in jail. And in one of those cases, just last week, a 4th expert found Mr. Fortier insane at the time of the offense, including 2 that were hired by the state. So I don't feel any better about where those cases are now than where they were when we made the decision. And on Mr. Garung's case, he is scheduled for trial in October, and he has been in the hospital since. So I think it's really important that, 1, we prosecuted them, we went forward with them, we did hours and hours of depositions and hearings with experts, and believed that we could not overcome the insanity defense. And as is our ethical obligation, dismissed the charges, knowing at the time that the 3 individuals would remain in the custody of the Department of Mental Health until they found that they were safe to return to the community.
Mr. Kenney?
Well, I'm at a disadvantage. I don't have access to the information that the state's attorney's office had or that the attorney general's office had. I was not in that part of the attorney general's office. And in fact, I was precluded from learning about it because of my role supervising people who did Department of Mental Health legal work. So I will say that they are extremely complicated cases. And it would be wonderful for me to opine away with what would likely be a popular answer. But the truth is, I can't do that. The only thing I would add is that, I've made no secret in my life and as part of my message that we've had mental health issues in my family. I had a brother who was paranoid schizophrenic. I have 2. One is no longer with us. He was murdered in Central Park in New York City while he was homeless, very likely by another person who had mental health issues. They never closed the case. Those cases are tragic. I know that from personal experience, but I also, and I know that from being an attorney, there's no good resolution to cases like that, and they're incredibly complicated. All I can tell you is that I will use every degree of mind and spirit that I possess to make sure that that every legal avenue is explored and that justice is done. But again, I just don't have access to those cases, so it's not what I say.
Our time is on the short side, but I want to get in a question from one in the queue, a person of color who asks you, Ms. George, to discuss why you repeatedly on Twitter and at a press conference on gun violence with the mayor and the acting police chief in Burlington mentioned supporting WJFI, whose mission, she writes, is to shut down the Chittenden Regional Correctional Facility, and whose website states that child molesters, murderers, and rapists should not go to jail. I'm not entirely sure what she's referring to, but have at it.
Well, that's not exactly what their website says, but WJFI is a women's justice and freedom initiative. They're an incredible nonprofit organization in our community that is working to shut down the Chittenden Regional Facility. I'm on the board there, And I think it's really important to have different points of view on a board, as do they. I trust their work. I am not myself an abolitionist, but they are, and I appreciate where people are coming from different perspectives and want my perspective in their organization to see how it can help or hurt their messaging and ways of becoming a community that doesn't incarcerate women. I think that there is somewhere in between there. I do think that the Chittenden Regional Facility should be shut down. It is awful. It is very old. There is mold. It is an unsafe condition for women. I think that housing them elsewhere, like the Johnson College or other colleges that maybe have been are no longer in use, finding ways to use a campus like that to have some that are still sort of unable to enter the community, and then others that can still see their kids and get jobs and find other ways to slowly transition back into the community would be a great middle ground. But just because I'm on the board doesn't mean that I can't have a different opinion on some things that they work on. They do really incredible work, and we don't always agree.
Mr. Kenney?
Well, I actually looked at that website after the statement was made at the mayor's press conference, because, and in addition, there was a tweet that went out that said that campaign donations that would be made on a certain day, 1/3 of them would go to that organization. That organization has 2 directors. The state's attorney is one of the 2 of them. It does state that it is there to abolish prisons. The website itself does not state that that murderers, rapists, and child molesters should go free. It actually links to another site that says that. But you know, that I take the state's attorney at her word that she's not in favor of that. But the organization is in favor of shutting down the Chittenden Correctional Facility and not building any new facilities. I've been in every jail in the state of Vermont. They are not good places. They are bad places. I've been in Chittenden, and I've represented women who have been abused in the Chittenden Correctional Facility in civil cases. It is a bad place. There's no question about it. It does need to either be substantially renovated or a replacement needs to be made. But I would not be in favor of housing these people who are women, but still they have committed serious offenses at a college campus or something like that. There does need to be a higher level of security, and there does need to be more of a concern for possible escapes.
I just want to make sure I didn't mean a college campus as it stands right now. There would obviously need to be some adjustments to it. My point was just a more open, accessible community for women who are incarcerated.
We have 5 minutes. I want to offer an opportunity for each of you to ask each other one question. Mr. Kenney, why don't we start with you?
When a 18-year-old man opened fire at the University Mall a year ago, he was a charge pending on him involved a home invasion in the city of Winooski, where he allegedly went in, broke the door down, had a firearm, and stole from that person, also threatening a neighbor. He was on a condition of release for a 24-hour curfew when the University Mall incident happened. That incident was where he saw somebody, and this is all alleged, saw somebody that he had a dispute with and opened fire into a crowd of innocent people. One person was injured, thank God, just with shrapnel. That person then escaped capture and was found out of state by the U.S. Marshal's Office. When that person was returned by the U.S. Marshal's Office, the state's attorney's office made a motion to transfer the case to juvenile court, meaning the criminal case would have been dismissed and it would have been handled in juvenile court. The question is this: the state's attorney's office issued the following statement, and I have a question on it. The state's motion to transfer does not mean the state will ultimately support a case being given youthful offender status. In order to ensure that a youthful offender program is fair and equitable, the Chittenden County State's Attorney's Office attempts to give every eligible youth a chance to be considered. Is that a policy? And if it's not, then what specifically about that case required this motion to be made?
Thank you. So this is one thing that is a lot of disinformation in the community about. Our new laws with our juvenile justice laws changed and made all cases for anybody under 22 to be sent to family court under youthful offender status. I want to say first, it does not mean the criminal charge is dismissed. It means the criminal charge is transferred to family court. And in a lot of cases when that first happened, what we saw happening was that those cases would get filed by our office and they'd be litigated for quite a long time. We'd go through motions, we'd go through hearings. And then towards the end of the case, a defense attorney would move to send it down to family court. And we would have to have the youthful offender hearing sometimes a year after the case was filed. So our office decided that for sake of efficiency and making sure that we knew and didn't waste resources on motions and hearings, that we would file the referral in most of those cases immediately, even if we objected to it, which we did in the case that you talked about. We objected to that case actually staying down in family court, but felt strategically that it is worth having the court weigh in, having the hearing, have DCF weigh in, get everybody on the same page immediately, so that we know from the beginning where that case is going to go. We objected to Mr. Smith's case being heard in family court, so it stayed in criminal court, and he is still incarcerated. He is a young kid who, has been in jail since this incident, and we are trying to figure out ways to safely resolve that case. But I'd much rather be in the place we are now than to have him or his attorney arguing a year later that the case should go to family court. So it's not a policy, it's just a legal practice that we do for sake of efficiency and frankly, legal strategy.
Ms. George, do you want to ask Mr. Kenney a question?
I think, sure. My question for you, Mr. Kenney, is you ran for this position in 2006 against TJ Donovan, and then you sought the appointment for this position against me, and you're running against me now. And you talk a lot about criminal justice reform, but I'm wondering if you can name one concrete action, not words and not thoughts about what might work, but a concrete action that you have taken to actually move criminal justice reform forward that has impacted a group of people's lives other than one particular client.
Well, the answer would have to be that on the select board, I have advocated for increased funding for the restorative justice. That's an important program when it's used appropriately. But other than that, you're right. I have not been state's attorney yet. So my ability to affect criminal justice reform has been severely limited. I'm hoping to change that.
All right, we have a lot more questions and not much time. Why don't we move to closing statements? And before we do, a reminder that this forum will be posted in its entirety on each of the four sponsors' web pages later today. For closing statements, why don't we begin with you, Mr. Kennedy?
Oh, thank you, Stewart, and thank you everybody else, and thank you to the state's attorney. There's nothing personal about this, and I honor the work and the passion that she brings to the job. Our differences lie in the policies, and I'm asking for people to consider voting for me so that we can affect new policies. Again, we have a new situation. The new situation with the increased rate of crime and the different kinds of crime require new solutions. I don't pretend to know every solution, but I'm not going to rest until I try things. And if they don't work, we'll try something else. We haven't talked a lot about qualifications, but just so people do know, I have had a public defense contract where I did every kind of, pretty much every kind of case, tremendous number of trials. I also did a juvenile defender case where I did a lot of child in need of supervision cases, et cetera. I've led my own office. I've run my own business. I've supervised about 30 people in the Attorney General's office as a division chief. I want to bring those qualities. I want to bring those efforts to bring about new policies so that we can have both criminal justice reform and public safety. There's more information on my website, tedforstatesattorney.com. I would ask people to go to that. And again, I thank everybody, and I ask for your consideration.
Thank you, Mr. Kenney. Ms. George.
Thank you, Stu, and thank you everybody who came and also those who organized this. I have been a prosecutor for 12 years, nearly 12 years, and I've seen a lot of policies play out. I've also seen a lot of policies fail, and I've seen policies change. And one thing I have been very clear about since I got this job was that we have to collaborate with the people in the community that are drastically more impacted by these policies than the rest of us, than me. Speaking with the most vulnerable people in our community, reading data and evidence-based research to come up with policies is a new idea, which is a really incredibly sad statement, but we cannot go back to the status quo. We cannot go back to policies that don't work. And we have evidence and data that says they don't work. So my policies may not be super popular to everybody, and I understand that, but they are based on evidence, they are based on data, and they are based on the real fact that people of color and poor people in our community are disproportionately impacted by our system. And it is harming them, and it is actually making all of us less safe. So I also want safe streets. I live here, my family lives here. I believe that we have safe streets, and the number of crimes that have gone up absolutely have to be addressed. But thinking that it's my policies rather than COVID and other moral issues that are happening in our community and health issues that are happening in our community uses me as a scapegoat when our community needs to step up and help people and give people the basic needs that they are severely lacking. That will make all of us more safe. And I hope that you will continue to allow me to do this work. And I promise you that I will continue to make decisions, the hundreds of decisions I make a day, the thousands of decisions I make a month in this role as a prosecutor to make sure that we have true public safety and a more just system for everybody.
Thank you, Ms. George, and thanks to all of you and to our sponsors. Early voting is available now. There is no Republican in this race. So the primary for the Democratic primary for state's attorney in Chittenden County is August 9th. Thank you all, and have a great afternoon, everyone.